Hey everybody, Jonas Callis here of the Hurt at Work Workers' Compensation Law Firm. Some of you may know me as the Workers' Comp Guy. First, the obligatory disclaimer. The following is for informational purposes only and does not constitute legal advice to anyone or create an attorney-client relationship with anyone. Today I'm going to talk a little bit about the concept of an injury by accident in the context of the Virginia Workers' Compensation Commission. Most work-related workers' compensation injuries stem from a specific identifiable accident or event or incident that occurs at work during a reasonably specific time period, okay? And maybe the easiest way to understand this is because other compensable things in Virginia's Workers' Compensation Commission are occupational diseases, right? But occupational diseases occur as a result of a prolonged exposure to something at work over time, right? So maybe the best way to think about it is most injuries by accident, you're able to, if you were looking at a video, you could point to it, right? You could point to it and say, that's it, right there is where I did it, right? Like you tried to lift up a loaded bucket of ice and had a lumbar strain, or you were just climbing down a step ladder and sprained your knee or turned your left ankle or something, right? You can always point to that on a video, right? So that would be an example of an injury by accident in the Virginia Workers' Compensation Commission. So today I just wanted to talk a little bit about what is an injury by accident and kind of what that means. I did have a lot more to say, but I think this topic can be somewhat complex, and I think it's easier to understand in more manageable, bite-sized chunks. So I'm going to stick to kind of just the basic definition of an injury by accident today. So what is an injury by accident? In Virginia's Workers' Compensation Commission, an injury by accident is an identifiable incident. That's what we just talked about, right? That occurs at some reasonably definite time. Again, we just talked about that. 3, which incident arises out of the employment in the course/scope of the employment and causes an obvious, sudden mechanical or structural change in the body, which has a causal connection with the accident. So the injury and the event have to be causally related, okay? So that's the definition. So what does that mean? Well, first of all, we already talked about this. Some event has to have occurred at work, right? And before we let's not get hung up on the word event, though, too much, right? So I know I just said you can point to it on camera, right? Well, sometimes, let's say someone is kind of a utility person at work, and a loading truck comes, and loading's not necessarily something they do a lot, but maybe the business is shorthanded that day. It's a small business, maybe they're a bit shorthanded. And they're asked to help out. Well, maybe it's a small delivery truck. It takes them 15 minutes to unload. Well, after that, they start, kind of back soreness and stiffness, right? So that's enough in many cases in the Workers' Compensation Commission. That might be enough. That 15-minute period where the truck was being unloaded could be enough to be a kind of a reasonably definite, defined period where an incident could have occurred, right? Particularly if the employee wasn't doing anything else strenuous that day, right? So we don't want to get too hung up on the word event, but at the same time, if you said, well, I was doing all kinds of stuff at work on Wednesday, so it happened on Wednesday. That's probably not specific enough, right? It was an 8-hour, 9-hour, 10-hour period, maybe doing multiple different tasks. Like, how can you really point to one specifically? So, now that said, right, anytime you you could if you didn't have a specific incident during the 15-minute loading event, just it happening possibly during the 15-minute loading event could be enough. But always, if you can point, no, it was during the 15-minute loading event, but I remember specifically lifting a certain box that was like 30 pounds or something like that. That would be, right, then you're kind of narrowing it down, okay? So that's definitely a specific identifiable event. Now, probably the issue that gives people the most both claimants and actually insurance defense, employers, the most trouble is the phrase arising out of the employment. Arising out of the employment refers to the time, place, and circumstance under which an accident occurs. Basically, it means there must be some sort of connection between the accident and the risk or hazard connected with the employment. That, what was that employee doing and supposed to be doing, and was that the kind of thing, the accident that could reasonably be foreseen to come out of that kind of activity, right? The phrase "in the scope of" or "in the course of the employment" is similar, but basically all that means is, was the employee, did the accident occur in a place where the employee was reasonably expected to be because of their job? So that was a little easier to understand. Lastly, obviously the accident, we're talking about an injury. We're talking about injuries, right? So the accident should have caused some sort of identifiable injury. And that's what the language "structural or mechanical change in the body" means. Now, fortunately, this is a fairly low standard, and the Commission has found on numerous occasions that contusions, which are bruises, are actual structural and mechanical changes. So you don't have to have a really bad injury to have a compensable work accident in Virginia. So that being said, I imagine that still it's probably as clear as mud, especially the arising out of part. So what I've actually found to be helpful, like I've given you kind of the legal explanation of it, but what I've found to be helpful is to look at it from the other side, right? So what doesn't qualify as arising out of, okay? Now we've gone over and we said, well, the accident has to have some sort of relationship to the job, the work being performed at the time of the accident, okay? That's what arising out of means. So if you look at it from the other side, in Virginia anyway, simple acts such as walking, bending, turning, with nothing else, just walking along the hallway at work and you tweak your knee or something, that's not arising out of your employment. Why is that? Well, because people walk everywhere. This is how Virginia reasons it. People walk everywhere all the time. You walk at home, you walk to your home, you walk from home, you walk when you go to the grocery store, you walk down the sidewalk to exercise voluntarily. People walk all the time. So if you're just walking and nothing more, right, that's not really related. That could have happened anywhere, right? You could have been walking at home and tweaked your knee. So that's simple acts, simple routine acts such as walking, bending, turning, are typically not considered, especially just by themselves, as a compensable injury by accident in Virginia. Likewise, something like walking down steps or up steps, whatever. We walk down steps, we traverse steps all the time, right? Outside our home, sometimes inside our home. When we go to concerts, when we go, we walk down steps a lot. So if all an employee was doing was just walking down steps at work, when the incident occurred and nothing more, then the Commission typically finds that that's not arising out of the employment. So I think that helps a little bit more. It typically takes more than just walking or just walking down steps or turning, just kind of turning as you're walking or whatever. Like I said, this is where a lot of arguments come from. And a lot of times employers and their workers' compensation insurance companies, the defense attorneys, will deny claims on the grounds of did not arise out of the employment type of thing. So it's highly litigated and it's a bit complex, but you should certainly be aware of it. So that's really all I wanted to cover today about just kind of the basic definition of an injury by accident in Virginia workers' compensation law. Thanks for watching my video. I hope it was helpful. Of course, after the accident, there's a duty to report that accident to a supervisor within 30 days. But I think I have another video about that. I'm not going to get into it. But please watch the other videos because the other videos, also my website has a lot of information that's designed to help injured employees kind of navigate their way through what's become an overly complex workers' compensation system in Virginia. So for more information, check out the website, www.hurtatworkinva.com. That's www.hurtatworkinva.com. Also, follow us on Facebook, Twitter, YouTube, because we have information there, more videos that try to explain things in a way that somebody who maybe isn't a legally trained workers' compensation attorney can understand to help them handle their own claim. If you've been hurt on the job or know someone who has, feel free to check out the website and videos and to tell them about it, right? If you find the information to be helpful, then probably someone else could find it to be helpful too, especially if they're going through the situation where their claim has been denied. And they're hurt, they can't work, they don't have income. Hopefully this information can help. I always find it, I think it's always better to have the information and not need it than it is to need the information and not have it. That's why I'm putting it out there. Yeah. Other than that, that's all I got for today on injuries by accident. Thanks for watching. Until next time, stay safe and don't get hurt at work.